Welcome, everybody. It's great to be here. Chuck Cook, managing partner here at Cook Baxter. Put up the official line. Today we're doing English. Of course, there'll be Spanish questions. I'll answer in Spanish, but there was a couple English really focused things today that are going on. First, and perhaps most important, is the H-1B lottery. The H-1B lottery ends on the 17th. I think that's Friday at noon. Today's the Ides of March. Be aware the Ides of March here, the 15th. But if you have a bachelor's degree education and a U.S. employer is going to sponsor you for a job that requires your bachelor's degree education, that U.S. employer must file for your H-1B by noon on March 17th. We're all caught up on our filings. We have a bunch of filings we've already done. We've been able to do some for the last couple of weeks. But if it's still not too late, close to too late, but if you have an H-1B that you want an employer to sponsor you for, they need to get in the lottery by Friday at noon. Key here is that just because you enter the lottery doesn't mean you're going to win. But if you don't enter the lottery, you're going to lose. So, if you don't win, you can't play. But again, the job has to be one that requires a bachelor's level education. You have the university degree, 4-year degree, and the job requires that. For example, you can't do an H-1B for an administrative assistant. That's not a job that requires a bachelor's degree. So if you have any questions about that, all you got to do, ASAP, reach out, ASAP, talk to one of our lawyers. Laura Rosemarin runs our business immigration practice. She can answer those questions for you. Of course, I can. That's the H-1B issue. So H-1B you have to be aware of. Now, just now, the Immigration Service just issued new policy guidance on what's called the ability to pay. Make sure I spell this right. Ability to pay. I put it up here on in a banner, out of banners. So let's get rid of some banners so I can put new banners up. Ability to pay. So this is actually a key part of immigration law for immigrant visas, first, second, third, fourth, and fifth, but really first through third. If an employer sponsors you for a job, the employer has to show they can pay you. They can afford to pay you. Now, ability to pay. It's called ability to pay. It seems very simple, right? Well, you have money or you don't. It's not that simple. Immigration wants from the U.S. employer a financial statement for the previous year. They want an audited financial statement or tax returns or annual reports. Audited financial statement. Only giant companies have an audited financial statement because they're expensive. They're really expensive. Mom and pop shop, people with 30 employees, they don't have audited financial statements. I don't have audited financial statements. That's crazy. You wouldn't waste your money doing that. And so if you don't have audited financial statements, and you don't have more than 100 employees, you have to go through a gigantic hassle to show the ability to pay the wage. So you need to get, for example, your bank statements, personnel records, bank account statements. If you're a sole proprietorship, you're doing this, income and assets of others, credit lines of credit, they are fully considered as part of the net current assets, which is something they really haven't mentioned before, that credit limit or lines of credit can count towards your ability to pay the wage. But they have to look at the overall financial issue. Now, the officers that are doing this, they have no financial background to do this with. So this is a new, it looks like a 15-page detailed memo on 3 words, ability to pay. They look at what are they supposed to be paid. And the simplest thing is look at the tax return. If the company the last fiscal year made more money in profit than that person's salary is, that's ability to pay. You clearly meet the standard. That's it. So the proffered wage, for example, is $50,000, and they're going to be paid $50,000, but they're only paid $40,000 the previous year. You have to come up with net current assets equal to greater than $10,000 for each year. So that's the kind of stuff you need to look at. They also look at all the wages. They look at the media accounts. So they're now going to look at the internet, how long you've been in business, how you've grown your business, recent business changes, disruptions. this is really interesting to have them do this. This is a good thing. This has long-lasting benefits for employers. And frankly, I welcome it. Thank you, immigration. Now your officers have to follow it. But let's make sure that happens. The next thing we want to talk about today is also really kind of important, and that is the 601 waiver case. Now, some of you are here listening to you're one of our plaintiffs in the 601A litigation, and we just concluded a conference call with government lawyers. Let me just give you a background of what's going on. We have pending a motion for class certification that is fully briefed, waiting for the judge to make a decision or have a hearing. The government has also filed a motion to stay, to stop all work on the case, because they're going to file a motion to dismiss. We oppose that. Judge isn't going to grant that. The government, today's hearing, today's interview, today's telephone call with the government was simply about something called a Rule 26F meeting. So the court requires us to have a conference with opposing counsel to go over a series of things, whether it's discovery, when a trial is going to be, when motions have to be submitted by, the timing for a case. It goes out over the course of the next 12 months, because that's how long cases like this can, if we don't settle, how long it could last. Now, we believe we're in a strong position. Should the court rule that there is a class action here, we think there's going to be movement towards settlement. And the settlement offer we have made is actually quite simple. Adjudicate all the cases in 6 months going forward. That's number one. Two, as you get, you're not going to do that overnight, but as you get to that standard, issue deferred action, issue a work permit, issue a travel document. Make people whole. Your delay should make us whole. You know, we shouldn't pay for your delay. But the key is the 6 month. It's not like we're not trying to ask for an EAD in place of getting adjudicated. We want the adjudication first. But, you know, that's going to take them body time probably to do that. So in the meantime, we want the other things. Now, they haven't responded to our request. But this conference call was about that. And so we agreed on some things. We agreed when discovery has to be completed by, which is in 6 months. We'd agreed when there might be a trial, although there's not going to be a trial in this case. It's going to be settled on motions, but a trial would be 10 or 12 months. Motions will be filed after about 6 months after we get out of discovery. And we might complete discovery before that. So this is just timelines. What we didn't discover is government doesn't want discovery. I mean, of course they don't. They don't want us to depose the director of the Nebraska Service Center, the director of the Potomac Service Center, or the person in charge of the 601A program, to explain how they went from 6 month processing to 3.5 year processing in a matter of a year. How did that happen? You know, choices were made, bad choices. We mollow choices. So that's what the status of that is. There's nothing more to share than that. We have this scheduling order agreement notice is due to the court on April 14th, and we're simply waiting now for the court on the motion for class certification, which is key to going forward on this case. Also, we found out, we talked about yesterday in our impact session, that we have about 70% of our clients. Our clients have had cases transferred in both groups, the first and second filing, which is great news. Now, one of the questions we will ask the government eventually is, why are you transferring files? You know, are you rearranging the deck chairs in the Titanic, or are you trying to get them to places where they can be adjudicated? That's what we think they're doing. And, you know, we'll ask that question and get that answer too. So that's the 601 delay litigation question that we really wanted to talk about. The last thing is really the chaos at ICE and the border. There was an article that came out today in the New York Post. Of course, it's a liberal, crazy magazine, but this is the headline. This is the headline of this. New York ICE office fully booked for migrant appointments through late 2032. So ICE released a statement that so many people have come to New York that for the next 9 years, they are full. They're fully booked. There's an appointment every hour of every day that people are working to meet. And I would tell you that's probably true in most offices around the country. It is a large number of new arrivals. And unlike it's not a record breaking. It's record breaking in the context of people are reporting at the border and asking for asylum. That is new. It's not a record number of people coming in the country. That occurred during Clinton and Bush, especially Bush. People just came in illegally, and they just disappeared. These folks are actually waiting to go to court. They're showing up, and that's what's great. You're thinking, so many people are showing up that ICE is full. That's awesome. That's awesome. But what that means is the system is broken. The system is broken. So it's chaos at ICE and the border. Chaos because the Biden administration doesn't have a plan. But I'm not going to blame them completely because they don't have a plan for a specific reason. Because every time they come up with a plan, states sue to stop it and say, I want you to force the law. And courts agree with them. And I think the courts are wrong. The president gets priorities, how they want to establish priorities on cases. But if they don't have the ability financially and body-wise to handle every case, what do you want them to do? Because Biden, if you want him to follow the law is when you show up at the border and say, I want asylum, you let them in. And if Congress hasn't allocated bed space to detain everybody, which they haven't, what can you do? Because you can't keep them out of the country because we say our law says you have to let them in. So yeah, this is a stunning problem. And Congress, what I love is the Democrats actually had a solution for this last session. Passed the bill in the House, would have solved a lot of these problems. Republicans don't want to solve it, so they didn't vote for it. Couldn't get 10 senators to vote for it. This is a Republican problem. This is presidents. I don't think he's a very good job in the context of managing it and selling it, but Republicans refuse to fix it. Just understand, they refuse to fix it. That's kind of the way it is. All right, we got some questions here today. First question is, Hola, abogado, buenas tardes, Silvia, gusto verte. Vanessa, one of my favorite people. Vanessa, you are doing really yeoman's work at Dreamers Together. You're helping so many people. It's just joyful to finally have DACA people wake the freak up and say, I can get a green card. Yeah, what am I waiting on? I had somebody in yesterday. They've been married to their citizen spouse for 4 years. What are you waiting for? Get the Advanced Pro, go, come back, get a green card. Come on, people. Really, what are you doing? Good work, Vanessa. Dreamers Together, great website, great Facebook page, great people, accredited organization to the Executive Office of Immigration Review. They can legally help people, even though they're not lawyers. They're smart people. They've been properly trained, and I helped a little bit. And I'm always there to help. Always, Vanessa. Mohammed, DD 2020 update. Oh, this is easy. There's no update. That was easy. Still pending. Good afternoon, Natalie. Oh, Natalie, good to see you. Reason why somebody would opt H-1B and then AB3 instead of go straight to AB3. Well, H-1B, AB3s are taking about 3 years, which means you're not going to get your green card for 3 years. The H-1B is a non-immigrant. So if I get picked in the lottery, I can be in the United States in October of 2023. Whereas if I'm out of the country and I want to do an EB3, I'm not going to get my green card. I can't come for 3 years or longer if you're Indian or Chinese. So they're different things. The H-1B is to work quickly in the United States. EB3 is for the green card. Now, for the people with DACA, you can do an H-1B. You don't need to because you have DACA. Now, H-1B is better than DACA because it's a non-immigrant visa status. You would leave it's the same way if you're eligible for EB3 consular processing and you have a bachelor's degree and your job requires a bachelor's degree, you would register for the H-1B lottery. If you get picked, you'd get approved. You'd go to Mexico. You get your H-1 stamp. You come back. Now you're not in DACA anymore. Your DACA history is over. Now you have a legal entry. Now you have your H-1B. Now you have status. And then you get EB3 from there. So that's why you would do that. Go! No! Hola, abogado. Saludos. Saludos a ti también. Carreno, abogado, tengo una pregunta. ¿Un residente puede arreglar a una esposa sin tener que salir del país? Solamente si la esposa es legal. Tiene estatus legal en el país. Si no tiene estatus legal, tiene que salir. Aunque entró legal. Tiene que estar físicamente legal todavía. Rosa, hola abogado, tengo 3 hijos ciudadanos americanos. La mayor tiene 28, segundo 26, tercero 18. He escuchado que ellos pueden pedir a sus padres si tengan que salir sin que tengan que salir y pagan una multa solamente sin salir. No, esa es una mentira, Rosa. Si usted no entró con visa. Si entró con visa, sí. Y yo sé que hay abogados por TikTok mintiendo acerca de esto, tratando de atractar consultas. Llámame y podemos solucionar su problema. Solo conocemos el secreto. Hay muchos abogados, o algunos abogados, cometiendo fraude en esto, en que están aplicando por un ajuste de estatus, por lo cual usted no califica, pidiendo un parol, diciéndote de salir y reentrar con parol, cancelando la primera aplicación y reponiéndolo. Esa, en mi opinión, es fraude, y yo no lo haría tal cosa. Entonces, Rosa, si entraste ilegal, sus hijos pueden pedirte, y si no entraste ilegal, no pueden pedirte, si no tienes un padre o madre que es residente ciudadana, o si no tiene una aplicación antes de abril 30 de 2001. How do you think this bill will pass? What bill, Sabrina? There's no bill. No bill is going to pass. There is no immigration bill that will receive a good bill that will receive 10 Senate votes. That does not exist. Republicans do not want immigration reform. They want to campaign on how bad Biden is. Republicans do not want immigration reform. I already gave my update, Abigail. You need to scroll back. Just go back in time to about minute 6 or 7. That's where I talk about it. Habrá una petición antes de salir a la cita consular por 3 hijos. Tendría que ser el perdón. O sea, uno de sus hijos le pide, aquí, cuando está aprobado, su madre pide el perdón, usted está aquí, de ahí fijan las citas cuando usted sale del país. Amnesty. There will be no amnestia. There's no amnesty passing. There's no registry passing. There is no immigration bill passing. That's just reality. That's just reality. Natalie, closest we've gotten, CR is back in, we were very close in 2007. I can tell you we were really close in 2001, literally right before the attack on 9/11. We were really close. We thought we were close in 2000. We thought we were close in 98. I've been doing this for 35 years. We've been close several times in the last 25 years. But we don't have the kind of Republicans that existed in 2007 and 2013 don't exist today. They don't exist today. They don't. ¿Cómo puede contactarme? ¡Ay, puede hacer esto! Llama el número. Ahí está el número. Puede llamar a la oficina y pueden contactarte con cualquier abogado aquí. También puede ir a nuestro sitio de web en español y en inglés, y todos sus abogados y sus números están allá. Again, if you have a consult, a question, a comment, you can just comment, right? You can email me. But if you want a consult, just make an appointment. You can do it online at immigration.net, or you can call this phone number. This is what we do. I mean, we help people fix their problems by telling them the truth, which some people don't want to hear. I apply for the visa. You're probably pretty close, Sandra. My guess is you're within about 3 to 4 months. Claudia. Abogado, buenos días. Un joven DACA con caso cerrado, cancellation definitivamente desde 2012, si puede pedir, si no tendrá ningún problema. No, si su caso está cerrado, debe contactar a un abogado para terminar su caso, en vez de ser cerrado, terminarlo, viájase, tenga un buen viaje, tendrás un buen problema. Sandra, good to talk to you as well. Any questions or comments, you let me know. I will be back. I got another question. Orlando. Buenas tardes, abogado. Yo tengo el DACA y ya salí del país con un parol hace un mes. Me casé con un... ¡Yay! Requisitos son lo mismo. Son lo mismo. Llámame, Orlando. Llámame. Mándame un email. Que aquí es mi email. Mándame un email y te mando los detalles. O si quieres, llamas por una cita y sacamos tu residencia. Felicitaciones. Awesome. Okay. Eso es todo por hoy día. Si tiene preguntas, llámame un email, fíjate una cita, y yo estaré en vivo personalmente el próximo miércoles a la 1. Pero el martes estaré con mis compatriotas en Impact al mediodía el martes. Hasta luego, hermanos, que tengan